But I want to make a broader point, actually, and that is that we will almost certainly fail to reduce the many inequalities that exist in American society if we insist upon trying to identify a single theory of equality that can capture what most ails us. To the contrary, at the conceptual level, we'll have to be exceedingly clever and adaptable if we want to make progress on any number of concerns. We will have to be willing to move effortlessly among different ideas with which equality shares a kinship. And we have to be willing to deploy other legal tools and other political ideas that can minimize the damage to already hard-won gains. At the level of vision, we must be able to toggle between what we might call the ideal and the imperfect. Our preferred vision of equality under excellent conditions and a sense of what we're willing to accept temporarily under less than ideal conditions. At the level of tactics, friends of equality will have to spend more time in politics rather than in litigation. We will have to pick our fights carefully in this jurisdiction or that one, seeking to build a robust culture of equality using as many different kinds of tools that we can get our hands on. Now, while this dire state of affairs may seem daunting, there is good news. As Americans, we've done this before. We have advanced the cause of equality against hostile or skeptical forces, even when our adversaries have been backed by an intense politics that would sooner destroy the stranger, the deviant, the dissenter, than recognize such persons' right to exist or even to flourish. Even in such headwinds, we can still make good progress. We just have to remember how to pursue equality in practical terms. All right, you might already be asking yourself, why should anyone ever have to settle for less? My answer is that you don't always have to settle for less. It's important to retain our first best understanding of equality and justice for times when the wind is at our backs. But it's just as important to develop an account of what a second best view of justice might look like. Since most of the time as lawyers, as activists, we have to make trade-offs under imperfect conditions to make what we might call good progress. Sometimes we have to settle for less because our political system is in fact designed that way. Under our system of government, no one can get her way 100% of the time. Divided government and the generally conservative disposition of the courts are a fact of life. A majority is entitled to govern according to its preferences most of the time. And those of us who belong to political minorities enjoy rights. But even those rights depend on the goodwill and the good faith of people in power to enforce those rights. And every major battle of equality, from the promise of voting rights to freed persons at war's end, to the regulation of sexual minorities in the armed forces, has taught us just how hard this work of equality can be. Progressives won't be able to run over conservatives and libertarians to get everything that they want. And they could litigate a million cases and never implement an ideal vision of equality. Now, all of this, again, underscores that compromise is a precondition to progress, though we'll have to hone our sense of what counts as good progress as opposed to bad progress. And that's where having a second-best theory of equality comes in. How do we decide when an outcome is a good second-best solution, something that we can live with, even though we call ourselves an egalitarian? Well, I say if it satisfies the following three conditions. First, that the outcome can reduce tangible, unequal harms, or that it puts a stop to a policy that threatens to worsen inequalities. Second, that the outcome develops some set of ideas or concepts or rules that can empower others to continue the fight on behalf of equality. Third, that the outcome avoids what I call tragic precedents, the creation of new judicial or political obstacles to the advancement of egalitarian objectives. Let's see if we can put some flesh on the bones. Consider for the moment that civil unions, something that at one point never existed, became possible in some states, such as Delaware and Massachusetts. Friends of Equality at that particular historical moment faced a very difficult question, which is, should they endorse civil unions as a partial solution to the situation where same-sex couples had no formal legal recognition of their long-term relationships? Was this good enough? They couldn't answer this question, and we couldn't answer it for them, unless we're willing to make some tough, pragmatic calculation about what's most important. First, the short run. Is it access to important social goods, like favorable tax laws, state-issued benefits, the ability to legally stabilize a household? That's most important. Or is it the cultural recognition on par with opposite-sex marriage? Friends of Equality also had to think about the potential long-term consequences of compromise at that historical moment, although these were much more difficult to predict. Would accepting civil unions dissipate the political energy for reform and leave those institutions in place in a kind of separate but equal condition? Or might civil unions instead be a sort of way station to something more complete? Same-sex marriage, despite what was said during that moment of resolution. There could be no guarantees, but here the strength and resources of an existing social movement can be important. Sometimes we have to settle for less out of desperation, as racial minorities sometimes had to do in the years before the Civil Rights Movement, particularly in the Deep South, in the criminal justice system. And I've written a little bit about that in the book. And certainly for years, gay rights advocates had turned out of desperation to common law tools like contract to secure some measure of economic stability and child-rearing guarantees, even without the recognition that comes with state sanction of one's union. But sometimes you can compromise from a position of strength, knowing that political momentum remains sufficiently potent that you can take a solid win and continue to push for more ideal goals, such as perhaps same-sex marriage. Now, civil unions appeared at that moment to satisfy each of the three conditions that I talked about for a form of practical equality that could be acceptable. It improved material conditions and legal stability for same-sex couples. It gave legal recognition that previously didn't exist. And it illustrated for all the world to see the importance of the principle of equal respect. Opting for civil unions, as some states did, didn't impair the debate over same-sex marriage, and it didn't end up taking the steam out of constitutional politics toward that goal. It didn't create an insurmountable obstacle to further constitutional politics. In fact, quite the contrary. It turns out that seeing the tangible evidence of visible, healthy, loving same-sex couples in lawfully sanctioned marriages underscored the value of empiricism to cutting through what we might call ideological gridlock. Now, my point isn't that civil unions was definitely the right answer at that moment, and that saying no to CUs was definitely the wrong answer. The point instead is that these kinds of dilemmas, having to make these kinds of trade-offs, are always with us. And we have to make tough calls about what approximates justice based on imperfect information. I said earlier that many approaches equality promise too much and deliver too little. My goal today is to promise less and maybe deliver a little bit more. What practical equality offers is a way of thinking through the cultural and institutional obstacles to equality and to offer a set of historical precedents where conceptual workarounds have helped friends of equality to make progress in those tough moments. So what I'd like to talk a little bit more about is how we can learn from studying equality disputes from the past. And in particular, I want to focus on two things. First, the kinds of objections that are often raised, explicitly or implicitly, to someone who is trying to vindicate a claim of equality. And second, what has been done in the past, and perhaps what we can turn to in the future, to sidestep those obstacles when they become seemingly immovable. In my book, I point to three recurring obstacles to equality. First are what we might call fears that a valuable social good, whether it's voting, marriage, or education, could be degraded if limits on access to that social good are removed or redrawn. We saw this particular concern voiced poignantly in the battle over VMI, the Virginia Military Institute's policy of admitting only male applicants. Now, defenders of the exclusionary policy argued at the time that allowing women in their doors would turn that unique institution into, quote, a pale shadow of itself. And it would, quote, dilute, if not entirely destroy, the special form of education that VMI provided. This set of arguments about the fears of the sort of consequences of equality run through all of the briefs on this side of the argument. Now, luckily, the Supreme Court didn't bow to that concern, though the justices understood that they had to address it. It was something that had to be dealt with. The way that Justice Ginsburg did it was to say the following: since some women have been categorically excluded from the institution, or that social good, based on a generalization that no women could make it at VMI, how do we really know that no women could handle the form of education that the institution provided? How do we really know that allowing access to that social good would truly degrade it, in other words? Perhaps only modest adjustments would have to be made. And this is how she tried to answer that objection. There's a second kind of objection that we often see in equality disputes, which I call the fear of stigmatization. Equality, the rhetoric of equality, is a very powerful discourse, and the reason why it's powerful is because it's fundamentally a moral one. That means that sometimes we will have decision makers that worry about stigmatizing the behavior of people in power, who treat others differently when they don't think that that opprobrium is deserved. As I said, much of the power of equality as a discourse comes from this morally judgmental dimension. And there will be times when people will feel it inappropriate to denounce someone's actions in these harshest terms, say to call them a bigot or a misogynist or homophobic. We certainly see this concern arise in disputes over policies that affect today gay or transgender soldiers in the military, and certainly in the contemporary bathroom wars that have left transgender students in the crossfire. I will turn back to this in a moment. When it comes to policy distinctions based on sex, there also remains widespread belief that some forms of differential treatment on the basis of sex is appropriate and not morally repugnant. And this sense seems to be different than when we think about race, where we generally now think that using race as a criteria is almost always pernicious. If rules aren't designed to target a group based on sexual preference or identity, but still fall heavily on certain sexual minorities, these people say, then these policies don't raise the same kind of fundamental concerns about the actual nature of the community itself. This is what we sometimes hear. Now, my point in all of this isn't whether the full moral judgment of equality talk may be deserved. It may well be in many situations. My point is that a desire not to call out administrators in such inflammatory terms as an enemy of equality, if you will, can itself become an impediment to justice. The third thing that we sometimes see is a concern over cultural or political backlash. And this can, at times, cloud a person's judgment. It can make them hesitate in doing the right thing. We saw this most visibly during deliberations over whether racial segregation should be ended, when judges, including the justices on the Supreme Court of the United States, worried in closed chambers that ending racial apartheid in America would, as one justice said, end the spread of liberalization and liberalism in the South. Or as another justice feared, provoke a giant blowback against the entire judiciary. When it came to same-sex marriage, that fear of backlash, which is sometimes overblown, actually became poignantly realized. Everyone now knows that the Obergefell case extended marriage equality to same-sex couples, but not everyone remembers that the first court to ever do so was in Hawaii, and that amazing landmark 1993 state Supreme Court ruling then prompted a state constitutional amendment 5 years later, wiping out that ruling, and sparked for a time a conservative movement to restrict marriage only to opposite-sex couples in various state constitutions, state laws, and even in federal law. Those were tragic precedents that whipped up outsized animosity against sexual minorities, interfered with the lives of same-sex couples, and took decades of mobilization to overcome. What's the lesson? No judge likes to be overruled, much less to issue a ruling and then see it popularly repudiated. And that fear alone can sometimes lead a person in power to be stinting in doing justice. I want to underscore that being clear-eyed about each of these obstacles doesn't mean that we have to give them overt credence. It doesn't mean that we have to bow to them. But being realistic about how hard it is to actually do the work of equality might mean that when public sentiment is not on our side, that we are willing to use alternative ideas and strategies to do some of this work and to avoid worst-case scenarios. A certain flexibility in our approach should be made easier when we come to the realization that equality's conceptual complexity doesn't just create problems, it actually creates opportunities. For when we disaggregate the principle of equality, we actually discover that it encompasses many different interrelated values: power, voice, dignity, respect, fairness, shared suffering, opportunity. And once we realize that equality isn't just about one value, but several, we can be more open to the possibility of using a variety of legal tools to vindicate those values, whether it's the principle of fairness or due process, anti-cruelty, as captured in places like the Constitution's Cruel and Unusual Punishment Clause, or even what I call the rule of reason, which isn't spelled out in any particular or single provision, but captures a set of ideas about rationality and empiricism. At certain historical moments, such as when the law of equality is not well developed, or when the institutional or cultural conditions aren't sufficiently congenial to our first best visions of equality, then an emphasis on these other ideas can do some of the work that we want equality to do. The famous Justice Kennedy opinion in Romer versus Evans is actually an excellent example of what I call doing the work of equality by other means. There, the court was boxed in by a terrible earlier precedent, Bowers versus Hardwick, from developing a robust theory of either privacy or equality. While we now like to think of Romer as an equality case, that's because it laid the groundwork for the later development of ideas of equal respect and dignity. At the time, however, Kennedy used none of the ordinary doctrinal tools that we associate with equality jurisprudence. He didn't go through the tiers of review. He didn't use the language of suspect classification. He didn't exactly say that sexual minorities qualified as discrete and insular minorities warranting heightened judicial scrutiny or protection according to the criteria set forth in Caroline Product's famous footnote 4. Nor did he follow the Colorado Supreme Court's lead by embracing its more robust rationale, which would have been that the fundamental right of gay citizens to participate in the political process had been abridged. That too would have looked much more like a traditional equality solution. Instead, while remaining flexible as to methods, Justice Kennedy found that Amendment 2 was what he called a status-based law that, quote, lacks a rational basis. and that seemed explicable only by animus. Now, I want to separate here the animus aspect of his rationale from the rational basis aspect of the rationale, because we've come to also an understanding of the case that seems to only think of it as an animus-based rationale. The key, I think, to that case, or this aspect of the case that I want to stress, focuses on his analysis that the law at issue, the Amendment 2, broadly affected people in the state on the basis of sexual orientation across a wide range of situations and institutions, and therefore rendered them seemingly unprotected from even what he called arbitrary discrimination. In other words, the law seemed to single out one social group out for tangible harms for no good reason at all. And Justice Kennedy painstakingly rejected each of the weak reasons that the state gave for trying to disable or disadvantage one group in that way. Now, this approach was imperfect because Justice Kennedy didn't present a robust theory of equality that would necessarily help gay people in other situations. It left open the possibility that other laws that treated gay people adversely could be justified. And it left in place the Bowers ruling that allowed the state to put gay people in jail for having consensual sex. There was no robust theory of equality that day as to why treating people on the basis of sexual orientation would be unconstitutional or morally wrong. However, at that moment, the resolution ended a major threat to the well-being of all gay people throughout the state of Colorado. The rule of reason preserved all of the hard-won gains, importantly, at the state and local level, achieved by activists that had convinced a number of jurisdictions to add sexual orientation to their anti-discrimination laws. And this outcome put some teeth into the rule of reason that made that tool potentially useful for other political minorities when it might be difficult to convince people to use equality jurisprudence to solve a dispute. And even more important than a reinvigorated animus approach or the rational basis approach that I find useful is a newfound skepticism about using sexual orientation to diminish some people's rights. And that skepticism could be harnessed to solve other disputes. Now, I think that something similar happened in the Gavin Grimm case. And for those who haven't been following that case very carefully, their Grimm student challenged a Virginia school board policy that required students to use the bathroom that corresponded to the sex assigned at their birth. And as a transgender person, Grimm believed that doing so worked a major hardship, and that complying with this policy unjustifiably treated him differently based on status. The judge in that case valiantly documented the harms suffered by Grimm, pointing out that the inability of Grimm to satisfy his basically bodily needs in peace caused mental anguish and shame and led him to avoid using the bathroom and also increased thoughts of suicide. Now, there are some ideal positions about equality vindicated by the trial judge in that case, including that the school violated the notion of equality embodied in Title IX of the Civil Rights Act. The judge also found that the policy violated the Equal Protection Clause of the 14th Amendment, holding that transgender classifications should be subject to intermediate scrutiny. These aspects of the decision, if they were to hold up, would go the farthest in helping transgender people. Whether this is a correct reading of the civil rights law or our current equal protection jurisprudence, at least the first part of this is being considered by the Supreme Court. And it's anyone's guess whether jurists like Gorsuch or Roberts would really read the words sex to encompass transgender discrimination. But there's another possible answer in the case, in the event these direct approaches to equality fail. In so many of the words, the trial judge on this record also and already found that the policy fails the rule of reason. The trial judge pointed out that there have been no complaints about Grimm's conduct at school, certainly not in the bathroom, and practical measures undertaken by Grimm, by the school, but the school itself, if they were willing to do so, could already preserve his privacy as well as the privacy interests of other students. And as the judge pointed out, quoting from an important case that had previously barred the irrational treatment of mentally disabled persons, City of Cleburne case, quote, mere negative attitudes or fear unsubstantiated by the evidence do not suffice. Add on top of this the refusal to alter Grimm's school records to reflect his gender identity do nothing to protect anybody's privacy interests. Now this solution, this alternative solution, this backup answer, isn't perfect. But it would go some way to minimize the harms Grimm and others like him experience, while continuing to educate the broader public about the many issues at stake in these kinds of controversies. And I think it satisfies the three conditions for an acceptable second-best solution in an equality dispute. After all, there are many forms of discrimination, and not all of them rise from hatred. Inattention, sloppiness, a willingness to rely on overbroad generalizations and unsound stereotypes, too, as Justice Ginsburg has reminded us, can contribute to inequality. The converse should also be true. When we demand greater scrutiny of the state's reasons for treating someone differently and expose some of those to empirical testing, we can help reduce the circumstances in which discrimination can occur. Now, some of you might worry that practical equality isn't radical enough. I disagree. It allows us to retain both our sense of high moral purpose while expanding our repertoire of methods of achieving those goals. So let me close by reflecting briefly on Martin Luther King Jr., whose life's work in the pursuit of justice and equality we celebrated yesterday. Quote, "The arc of the universe is long," he is remembered to have said, "but it bends toward justice." This statement has often been misunderstood as a claim about the inevitability of justice. But King didn't mean to reassure people that unequal conditions would somehow change all on their own. To the contrary, King spoke of, quote, meandering points of bewilderment and, quote, inevitable setbacks. But he emphasized that, quote, whatever a man soweth, that he shall also reap. He's more specific in his letter from a Birmingham jail that his primary interests, or excuse me, his primary audience, at least the audience for direct action, encompasses white Christians and Jews and other people who he called moderate brothers and sisters, who could be allies if only their conscience could be awakened to the, quote, brutal facts of racial segregation. King was, above all, realistic in what it would take for that to happen. And he advocated what he described as persistent, determined action, not just negotiation, but freedom rides, marches, sit-ins, boycotts, as well as lawsuits. King appreciated that he would have to use a variety of appeals to do the work of equality. Love instead of hate, oppression and freedom, immorality and goodness, mendacity and truth, degradation and respect, unfairness and what is due, progress over complacency. He was accused of extremism. He embraced the term, but he remade it, calling his nonviolent program, quote, creative extremism. His fierce example of practical equality should be our own. Thanks so much for coming.
Thank you so much to Professor Tsai for that wonderful talk and for this wonderful book. I have to say, you will get no disagreement from me here. Professor Tsai stated at the outset that he is here to convince us of the need for practical equality. I am fully convinced. So what you will be getting from me is just a slightly differently inflected perspective on why his work truly matters and why the various approaches that he maps out in his book are so truly important to equality work. So in his book, Professor Tsai does a really, truly excellent job of reminding us that equality rights are are not the only nor even the primary way that equality work gets done. I wholeheartedly agree with that. In fact, I might go even farther in suggesting that rights are rarely how we secure equality. They are the end product of the work that is done to persuade people that inequality exists. Not just because we're divided, but also because a critical part of equality work is always deconstructing the lies that we tell ourselves about why the world we live in is not fundamentally unfair or unequal. So at any given time, the reason that inequality can be maintained is because large numbers of people are able to persuade themselves that it's justified, right? We need think no further than the Declaration of Independence and our framers pronouncing all men are created equal while simultaneously owning slaves. So although we talk about equality rights under the Constitution or equality laws, statutes, the reality is that those rights can rarely be gained or meaningfully enforced while people believe there are good reasons for inequality. We have to get people in what I think of as an equality frame of mind about a group or a practice, and rights don't necessarily get us there. So each of the methods that Professor Tsai talks about in his book as a form of practical equality, I think are important to this process of allowing people to arrive at an equality frame of mind. Indeed, I would suggest they are often more so than the rights-based frameworks that we so often focus on and celebrate. So what I'd like to do with the rest of my time is just briefly walk through each of the examples that Professor Tsai gives in his book of forms of practical equality, and discuss how I see each of these as being connected to this important process of undermining the reasons why people think the structures of inequality are justified. So starting with fair play. So as Professor Tsai properly points out in his book, for many equality-based social movements, fair play, due process, especially in the criminal justice system, has often been one of the first gateways to any form of relief in the courts. Right, so certainly in the case of the civil rights movement, before you were seeing decisions under the Equal Protection Clause, you're seeing due process-based decisions overruling profoundly unfair criminal justice decisions in the South. So how might this actually not only achieve results in a particular case, but start to open the door to broader equality work? So there's a reason I think that you often see this as the first crack in a system of inequality. Even those who might otherwise find inequality to be justified against a group in lots of other contexts may be able to see the unfairness of disparate treatment in the criminal justice system when it is clearly presented to them. Obviously, this is not true. We see lots of unfairness in our criminal justice system today, but when a particularly direct and egregious example of inequality against a group in the system arises, where the procedures are not the same as what are given to other folks, I think that can open up opportunities for people to perceive inequality in ways that they might not have in the past. We've seen the same thing also in the LGBT rights movement, right, where the move to decriminalization was sort of a first step towards people being able to see that inequality existed. The rule of reason is the second sort of form of practical equality, what people might more colloquially think of as rational basis review. I completely agree with Professor Tsai that this is an incredibly important tool of equality work. In fact, as I've written, I think it is only through revisionist history that we've forgotten that much of the work of 20th century equality law was done through the work of rational basis review. And this is the tool that really goes the most to the heart of the project I'm talking about here, which is undermining the reasons why people think certain forms of inequality is justified. Again, as long as people think inequality is justified, there will be obstacles to rights doing their work. We've seen that time and time again. So it's critically important not only as a precursor to equality rights, but also for the effective enforcement of equality rights for this process of undermining the reasons people think inequality is justified to occur. I think of the crack cocaine disparity as an excellent example of this, right? When it's first enacted, there are lots of people who think it is justified empirically, that crack cocaine is so much more dangerous than powder cocaine, that this is not about race, that this is, even though it has this obvious, enormous racial disparate impact, that it's justified by these real reasons. It's only through the process of people really working both in the courts and in the legislatures to help deconstruct those reasons, show that they are not actually true, that all of these sort of profound beliefs people had about why this was so dangerous don't actually support the policy, that people come to be able to see that it is racially discriminatory. And that process actually started with a rational basis review case in Minnesota, striking down Minnesota state disparity, which then led to the Sentencing Commission, the Federal Sentencing Commission starting to question its premises. No cruelty, another really important precept that Professor Tsai talks about in his book. No cruelty really to me is about making sure that we don't ever put anyone outside of the protections of the circle of humanity. Because of course, if we do that, all bets are off and any form of unequal treatment becomes acceptable, even deviations from our most basic commitments like no torture. As somebody who's done work with prisoners, I see this as a very real risk. There are profound pressures on those who work in those types of environments to distance themselves from the brutality that they perpetrate by conceptualizing those who they work with as less than human. But once somebody is no longer viewed as a human, right, there really are no limits on that equality can impose on what people are willing to do. In the Trump era, I feel like we have seen this dehumanization go viral in a way that is discouraging. Because of course we couldn't possibly do some of the things that we're doing today, for example, to children at the border, if we viewed the people involved as people. To me, anti-cruelty norms are the sort of bulwark. They are what beckon us away from these dark places and say we must have some basic boundaries on inequality. Everyone is a person, and there are certain things that entails no matter what. And of course, that is really our most basic starting point for any equality work that we might hope to do, which is recognizing our shared humanity. Finally, free speech, which is the last area that Professor Tsai talks about in the book, the ability not to be criminalized for what we say, who we are, what we believe. The connection here to doing equality work should be apparent to all, right? Our most basic requirement to changing hearts and minds around equality is that we have to be able to speak up about it. So all of these areas, again, I think not only are they sometimes the second best way we need to get things done, but I would go even further and suggest they're often the ball game. They're how we get from here to here, there in making equality change happen. So thank you very much for this excellent book and for your excellent talk.
Not sure if that's the impeachment trial or whether it's...
I just shut it down because there was people just chatting in the faculty lounge. I don't think they realized there was a talk going on.
Should I
So
say
I think, yeah, I think we should open up for questions, and also Professor Tsai, if you wanted to, in answering any questions from the audience, wanted to address some of Professor Iyer's points as well. I think that would work great.
Yeah, I'd love to just open it up and maybe just incorporate my responses to questions. And great.
Thank you so much, Robert. Thank you so much for coming and sharing your work. I'd love to hear you elaborate a little bit between the link between practical equality on the one hand and institutional considerations on the other. You at one point said we need less litigation and more politics, which is, I think, is what you said, right? Yeah. Which I would totally agree with. But it seems to me that many of the alternative approaches of equality you talk about in the book are judge-driven or judge-dependent, whether it's assessments about rationality or fairness or even free speech protections. So, I completely agree that progressives need to pay more attention to, for example, individually, legislatively created individual rights. But I worry that the practical equality that you're talking about doesn't get us outside of the courts as much as maybe we should be.
That's great. I think that in terms of institutions, the desire to, the impetus to have or develop some more coherent sense of what we're willing to live with as second best answers to equality. By the way, I don't try to say this is the one vision of second best equality and either take it or leave it. The book tries to offer some tools for people who will disagree, both about their ideal notion of what equality looks like, but also what they're willing to tolerate as second best. But it offers them tools for thinking through this problem. And the reason why I think it makes sense to think about what you're willing to accept is because given institutional realities, without thinking about what you're willing to accept, it's just this sort of haphazard, ad hoc, right, set of outcomes that just happens to us. And it can be incredibly demoralizing. And it also, and I think this is also an institutional point, which is not having this well-developed sense of what we're willing to tolerate hurts us in terms of how we think about investing our resources, right? How much of our resources should go into litigation versus activism, right? There's only so much money and time in one's day, and we have to be willing to know in advance who is willing to do the things that will promote the kinds of equality that we think can be accomplished. So I think that's kind of the heart of the book, and I'm not sure if that directly answers the concern. So if you want to reformulate the concern, Carlos, any more than that, but that's the guts of the book. And when I consult these historical examples, I do so just to offer lessons about how people get stuck when they talk about equality in the traditional way. And I try to show that at times it occurs to somebody to find a kind of a workaround. And oftentimes examples are in court. Those are the ones that I'm most familiar with, but they're not all in court. For instance, there's a place in the book where I actually point out that at one point the Underground Railroad is described as a form of practical abolition, and that's all outside of the court. And the way that people who participated in the Underground Railroad thought about that was, look, there's this huge moral question and long-range effort to end slavery, and it sure is taking a long time, and it's hard. In the meantime, we have to minimize the actual harms that people are suffering, and so let's take these risks and siphon as many people as we can out of the South. But there are drawbacks, right? And they actually saw very clearly what those drawbacks were. The trade-offs were that if you siphoned enough people out of the South, then you might reduce some of the necessary tensions for ending slavery that much sooner. So they understood that even something that was a kind of a practical and short-term effort to reduce the actual harms that I sort of talk about, there's no easy answer. And so the answer that occurred to them was to do both, right? To participate in the long-term moral efforts to end slavery, but also to do these other ad hoc kinds of things in order to reduce the suffering where they could. So that's kind of, I think, outside of the courts, those kinds of historical examples and the ones involving the dilemmas over whether to accept civil unions or not, to embrace those, probably are better things to think through, again, because you're not weighed down by the doctrinal stuff as much. I don't know if that helps, but that's, so I guess one way of answering your question is that different historical moments maybe can yield different kinds of answers for us.
So I think I was next. So I'm struggling with this. So first of all, thank you for this. It's very intriguing and thought-provoking. I guess I'm struggling with it on a few different levels. So one is, and I sort of relate to Carlos's question about, it feels like this is a very court-centered narrative of when practical equality should kick into place. Because I think about the importance of different social actors taking on different roles simultaneously, right? So for example, in any effort to kind of move the needle on equality, whether, and my specific area of expertise is in the context of race, you always have the people who are sort of willing to accept second best, and then the people who are sort of radically pushing the envelope, and you need both of those actors sort of working together across the spectrum in order to create not only an objective in the immediate term, but also in the longer term, right? I mean, the sort of the radicalness of King was that he understood the need to appeal to moderates in order to move them sort of, you know, past where they might be otherwise inclined to sort of land. So I guess that's just sort of a comment. And then the other, so I don't know if I have a question or a comment, but anyway, I'll try to do the thing of making it seem like I'm asking a question, but really it's a comment.
Yes.
But then the other, I guess the other comment is about, so when you lay out the criteria of fair play and rationality and making sure that we're sort of speaking to, or not placing people outside the boundaries of human concern, right? So the notion that that conclusion can be arrived at through a sort of sense of rationality and some kind of objective notion of what that means, rather than factoring into that question how implicit social judgments, right, build into what we think is rational, to what we think sort of constitutes the area of human concern. And so I guess I'm trying to kind of press you on the limits of practical equality given those considerations.
Yeah, no, I think those are great. Those are great questions. One way to think about the different, what I call possible alternative concepts with which equality as a principle shares some kinship, is that there's always, one way to think about it is that there are different forms of discourse, and there are always sort of comparative advantages between the forms of discourse. There is an important role for the discourse of equality. It's most powerful when we have someone that is categorically excluded from what we might identify as a critical social good, and we can get agreement about those two pieces. And throughout history, we can see that. That's why segregation is kind of the quintessential example in that. That's why the VMI case ends up being so powerful, the pro-equality position. But so many of our problems of equality are not so cleanly presented. Let's think about all the people in the world that might be affected by America's policies, where there could be an unequal component, from the treatment of refugees or migrants to students, to people who are incarcerated. One of the obstacles that we see in the traditional discourse of equality is we can fall into a trap of being stuck in a conversation about who is deserving of equality, who is already a member of the political community. That's sort of our oldest way of thinking about notions of basic equality. And when we ask that question, people like migrants and students, and these are all incomplete or partial people within that discourse. We're not limited in the same way when we sidestep that and talk about some inequity in front of us in some other way, whether someone in front of us is deserving of what they're due or should not be treated in any sort of cruel and degrading way. Those ways of talking have not been limited in the same kind of way. So I guess that's what I would offer. I would present it as different forms of discourse that are inside and outside of the courts. And so I guess I would push back a little bit and say that even though a lot of my examples seem to be about the courts, that's only because I want to make it very acute that there's power that's important here, power that needs to be unlocked, power that can do some good in reducing inequities. And in the courts, we're just most used to seeing when that gets frustrated and when it actually gets unlocked. And so a lot of the moments that I talk about, like the judges or someone else gets stuck in one of these circles, and then someone offers a workaround, and that workaround breaks through the logjam. So in the context of race, I try to limit my examples to sex and sexual orientation. One of the examples I talk about is efforts to desegregate schools, and part of that resistance to Brown, of course, is the enactment by a number of state legislatures of laws that limited the ability of cause lawyering. And Virginia was one of the states that did quite a lot of this. And according to one of the provisions in Virginia law, a lawyer couldn't take a case if they didn't have like a pecuniary interest in the outcome of that. Well, that describes like every public interest case. And so the NAACP, of course, and those of you who study this know this, would have been put completely out of business. When that case comes before the Supreme Court of the United States, there are only 3 justices who are willing to see it as an equality case. And they're determined. They're like, this is a straight-up effort to undermine Brown versus Board of Education, including Chief Justice Warren. He says, this is a straight-up equality violation. I'm prepared to go this way. Who's with me? And he looks around the room, and there's only 2 other justices willing to do this. Frankfurter won't go this way. Why? Because the social good at issue is something that has been traditionally regulated by the state. This is the practice of law. Nobody has a right to practice law, he says, right? In a way that any way they want to. The state of Virginia has long had the ability to completely regulate the practice of law. So he's not willing to see this in a traditional equality way. And if you force him to see it that way, he was going to vote against this equality position. This, to me, would have been a totally tragic outcome because desegregation would have come to a halt throughout Virginia. What happens? Someone comes up with a clever idea to, I think it was Hugo Black, we'll have to go back to the chapter in my book, says, let's think about this as a free speech issue instead. And let's think about how, when we think about it as a free speech issue, we're not restrained in the same way that we have been in thinking about it as an equality issue. That ends up turning what would have been a devastating loss into a 6-3 win under the free speech. So a lot of the examples that I give are kind of like that, where there's a moment and then people get stuck. And I think the hardest questions are when you in recognizing when you are stuck, and then at that moment being able to go to a second best. And because you don't want to move, and I think maybe this is some of the concern here, you don't want to move to second best when there's a good shot at getting your ideal vision implemented, even in a small way. But I think that's just something that we have to live with.
Hi. So I'm predisposed to your idea, and I view it as a form of arguing for incrementalism, although you may object to that term, I'm not sure, but maybe sort of in that genre. Now, if you want to defend that, it might be interesting to think about areas where it hasn't worked. The areas where it has worked, so, Thurgood Marshall first argues separate, but they're not equal, right, before finally gets to the point where he thinks, well, maybe we can win on separate, and even if we admit they're equal, still unconstitutional. And you raise civil unions as an incremental step towards marriage equality. But I wonder if you've considered or could mention any areas where incrementalism has failed. And it could fail in a couple ways. It could fail by pursuing that, or pragmatic or practical approaches have failed of taking some, but not the full goal. It could fail by backsliding. It could also fail by becoming stuck and going no further. I have to admit, I can't, off the top of my head, I can't think of a lot, but I can think of one that's coming. And I'm pretty sure it's coming, and that's the Establishment Clause. And we're going to see, I would predict, some real backsliding and a reintroduction of religiosity in the public schools. And it will probably come in the form of, it's quote unquote voluntary, right? So that's where the backsliding is most likely to come. And that is an area where I think you can think of it as a form of equality of religious minorities in order to secure equal treatment needed to secure victories at the Supreme Court level that would take the dominant face out of the public schools. And if we see that backsliding, right, it's an area where incremental gains were made. The court was very pragmatic and measured and sort of, okay, well, no prayer in the schools, but you can still have a prayer to start a government function, or, it's very incremental, pragmatic, practical. and we're probably going to see balance. But I'm just wondering if you could talk about areas where your approach hasn't worked.
Yeah,
In the sense of we've actually seen backsliding, or maybe just it sort of gets stuck and really for quite a while doesn't proceed any further.
yeah, certainly in terms of the religious examples that you're talking about, those are some of the hardest, those pose some of the hardest questions that we face in all of constitutional law, right? Because we have these robust protections, or at least they're supposed to be robust protections for individual conscience and the ability to worship. These go way back, and yet we also have this anti-establishment, right, promise, and those two things can sometimes collide in ways that are very uncomfortable. Part of the project that you're describing about using, say, for example, free speech ideas to kind of introduce or reintroduce more religiosity, if you want to see it that way, into those public spaces. That's been going on for a while, and I suppose for some of those who are interested in that project, who've been committed to that project, they do see using, say, free speech as a kind of alternative to maybe more robust notions of religious equality, right, that progressives don't agree with. So, in other words, in a way, you could probably describe some of their techniques as some of the things that I'm talking about, even though we might fundamentally disagree, or they might disagree with progressives in terms of where those lines ought to be drawn. You mentioned incrementalism. I think the only thing I would say about practical equalities is actually it's a way of not being incrementalist, because the way I understand incrementalism is that the minimalist in a kind of Sunstein sort of way, or Burkean kind of way, really is committed to doing kind of the minimal available, and they're committed to doing the minimal available because largely they want most of these things to be just sort of duked out somewhere else, right? Not in the courts. They want it to be duked out in the public sphere, in the political branches, and then where the chips fall, they fall. And so, Sunstein's, I think, read on a case like Romer is to defend it as a thin slice of equality, I think, as I recall, as opposed to maybe the way that that Professor Iyer or I would talk about, which is that there's actually kind of different tools here in this case that are being used, and it's not necessarily about equality exactly in the way that we had understood it at that point. And that's both good and bad, right? It's not good in the sense it's not full-throated in the way that's most useful, but it is helpful in some of these other ways that it can empower activists on the ground, or maybe convince the occasional skeptical judge in the future to be open, right, to claims of differential treatment on the basis of sexual orientation. So I'll have to think a little bit harder about obvious failures. I mean, I think in the abstract, I would say, yes, there's always a risk that if you jump to a second best solution too quickly, you can lock in something unfavorable, right? You could lock in some kind of doctrinal tool. You could lock in some set of cultural attitudes, right, that are damaging, that can become these kinds of roadblocks, or the worst yet would be like a tragic precedent that really is difficult to undo. So I think that's what I would think about, is that I would count that as a failure, as a true failure, as opposed to, oh, this is an outcome that I don't really like. I would look for these impediments more so. Oh yeah, sure. I know.
Okay, so so I understand that your main focus in the book is on constitutional litigation as opposed to politics, but yet you've conceded that there's sort of a political model here as well. So I want to ask a question which is going to totally put you on the spot, which is, we've seen similar kind of disagreement within the Democratic primary about, should we be pragmatist or should we be how progressive should we be? So the question is there any candidate or position that you've seen
my gosh.
who
Are we still taping?
reflects who reflects